Most people know they should have an estate plan, but fewer people know what exactly should go into it. Hi, my name is Tim Ivey. I'm an attorney with Trowbridge Nieh LLP, and today I thought I would talk about 4 core estate planning documents that everyone could benefit from, and one document that's of particular importance to parents with minor children. Now, an estate plan is meant to really cover 2 situations. One, you're alive, but you can't make decisions for yourself, and so you need someone to step into your shoes and make those decisions on your behalf. And 2, you've passed away, and now someone needs to figure out how to distribute your assets that were left behind, and if you have minor children, who should be their guardian and who should manage their assets. Let's walk through the core documents for each scenario. So the first document is called a durable power of attorney. And this document is intended to name someone your attorney in fact, who can then step into your shoes if you're incapacitated and manage your finances on your behalf. It lets someone you trust pay bills, manage your accounts, handle your money matters, pay your medical bills, whatever the case might be. They can liquidate your assets and even enter financial agreements on your behalf. Without this document, your family's going to have to go through court to get court-ordered conservatorship, and this can take time and money, and this is particular importance of when time is of real value. People need to be able to move fast when you're incapacitated to be able to make sure that your needs are covered, your finances are managed. It's a document that a lot of people forget, but it's actually really, really important. And it comes in 2 flavors. One is effective immediately durable power of attorney, and another is known as the springing durable power of attorney. Effective immediately is exactly what it sounds like. Once you execute these documents, your attorney in fact can immediately start making financial decisions on your behalf, and the springing power of attorney requires a determination of incapacity. Now, most people hear this and they think, oh, okay, I'll go with the springing power of attorney. That makes more sense because I really don't need this document. I don't need someone else meddling in my finances until I'm incapacitated. But the problem with that is a lot of banks won't recognize the springing power of attorney. They really want something that absolutely confirms that you're incapacitated. And so now you got this other hoop that you have to jump through in order to access people's finances. So it's much better to just find someone you trust and have them sign or have them be named as the attorney in fact in a durable power of attorney, which is effective immediately. And the reality is this: if you wouldn't trust this person to manage your finances when you're not incapacitated, then why the heck would you trust them to do it when you are incapacitated? So there's no good reason to go with the springing durable power of attorney for most people. The next document I want to discuss is a healthcare proxy. Now, this document is used to name who will make medical decisions on your behalf if you're incapacitated and can't make those decisions for yourself. This is a really powerful document. It lets you lay out what your preferences are if, for whatever reason, you're in a situation where you require, for example, life-sustaining care, and that life-sustaining care is the only thing keeping you alive. You might not want that. You might prefer that they cease life-sustaining care and let you pass away on your terms. Well, this document lets you tell your agent that's what you'd prefer and that's what you would want. Additionally, if you have religious convictions, such as you don't want blood transfusions, you can lay that all out in this document and your agent will honor those wishes. So you want to name someone you trust, you want to have that conversation with them so they're ready and you're sure they're willing to take on that responsibility. And this can be really powerful in helping avoid your family from having to guess what it is that you would want, and furthermore prevents them from fighting if they disagree about what would be the best thing. The next document I want to discuss is the one that everyone thinks about when they think about their estate plan, and that's their will, your last will and testament. This basically directs who gets what and names your executor or personal representative, depending on jurisdiction, to carry out your last wishes. Without one, the state's intestacy rules get to decide. That's basically the courts will distribute your assets based on what state law is. And so that might not be what you want. And so a lot of people this helps also avoid fights. It reduces fights and family disagreements. Sometimes if there's not a clear written distribution of assets, people are going to fight over the family heirlooms, the Fabergé egg, the china, grandma's ring. In our family, it's going to be grandpa's Budweiser helmet. That's the one that everyone wants, everyone thinks they're going to get. So grandpa's going to need to have a good will written that says this is the person who's going to get it. And that's usually figured out in a separate document that's part of the will called a personal property memoranda. Important to know, a will doesn't avoid probate. It has to go through probate. And so it's not a private document. This becomes a matter of public record, one. And two, it does take some time for these assets to get distributed because it has to go through those probate proceedings. That being said, if avoiding probate or reducing your probate exposure matters to you, and it should, then it's the next document that you're going to want to pair with your will. So the next document I want to discuss is a trust. Now, trusts come in all sorts of flavors. They're highly customizable. They can serve a lot of different functions, and they're very, very, very useful documents. The basic form of a trust is what's known as a revocable living trust. Now, what this does is it enables you to put your assets, put your stuff, put your property, put your house, whatever it is, into the trust. It becomes the trust's property. And now that is controlled by a person known as the trustee. Now, the trustee doesn't get the benefit of those assets. They just get to control those assets within the limitations of the trust. Now, this lets you control how and when assets go out. So, for example, this can be very useful if you have minor children, or perhaps you have gambling or a history of substance abuse among your beneficiaries. And so you don't want them to get a lump sum because you realize that that lump sum might not be in their best interests. Well, you can tailor the trust in such a way so they don't get it all at once like they would with a will. They would get planned distributions that have, certain conditions that need to be met. Sometimes it's age, sometimes they have to accomplish something like finishing college. It all depends on how you want to tailor that. And that's one of the real benefits of a trust, is it can be highly custom tailored. Furthermore, trusts will reduce your probate exposure because you're basically turning your assets that are ordinarily probate assets and would be subject to the jurisdiction of the probate courts, you're turning them into non-probate assets by putting them into the trust. So this has two advantages. One, it limits your probate exposure, so that reduces your court-related expenses. And two, it enables your trustee to immediately start distributing assets upon your death. You don't have to wait to go through the probate proceedings. Now, important to understand is that you still need a will. It's just the type of will you might have if you have a trust will change. You'll use something called a pour-over will, and the way that works is anything that you didn't put into the trust during your lifetime, the will pour over into the trust so that everything ultimately lands in the trust and then is distributed based on the provisions within it. Another thing that a lot of people don't think about is when you die, you owe estate taxes. Now, I'm going to talk about this in another video, but just real quickly, it depends on how much you have in your gross estate at death, but at the federal level, estates with more than $15 million in assets have to pay a tax on those assets. So if you have less than $15 million, you don't really have to worry about it. But many states, not too many, they're in the minority, but some states have their own estate tax. Massachusetts is one of these states. California and Texas, in contrast, have no state estate taxes, but Massachusetts does, and it's actually a much lower threshold. It's $2 million. And the way that threshold works is it's actually a cliff. So once you go over that threshold, once you're $1 over the threshold, you're going to owe taxes on every single dollar, not just the one that went over, all of it. So it can be very surprising for a lot of people, and $2 million still sounds like a lot of money to a lot of people, but the reality is that your assets add up pretty quickly. You might have equity in your house. You might own your house outright. You're going to have bank accounts. You're going to have retirement accounts. You might even have life insurance. plan that qualifies towards your gross estate. And so all these things add up, and people reach that threshold a lot sooner than they expect. And so certain trusts, not all trusts, but certain trusts can be used to reduce your estate tax exposure. So multiple things that trusts can help you with. One, they help your family get immediate access to your assets after your death within, the limitations of the provisions in the trust. Two, it helps reduce your probate exposure, which can enhance your privacy and reduce your court fees. Three, it can, if you're using particular types of trusts, reduce your overall tax exposure. Okay, so the next and final thing I want to talk about, and this is one that applies to both scenarios, both death and incapacity. So this is called the parental appointment of guardianship. Now, this document is one that I think is really important. I particularly think it's important because I have 2 young children myself, and I think all the time, what's going to happen to my kids? Who's going to take care of my kids if something, heaven forbid, happens to both me and my wife? Now, this is a document that's going to be executed by both parents. And basically all it's doing is it's nominating someone to the court to be the guardian of your children if you're not able to do so. This could work if you're incapacitated or if you're dead, either scenario. And so that's why it's so important to have this. Now, a lot of wills will also have guardianship provisions in them that stipulate what you would like to happen, who you'd like to have care for your minor children if something happened to you. But the problem with that is that the will is only effective at your death. It's not triggered upon your incapacity. It's only triggered upon your death. And there's another element to that, and that's it. Most people have individual wills. Even if you get a joint estate planning package where you and your spouse both get an estate plan together, typically you'll both still want your own wills. And so those wills are not joint documents. And so you'll want a joint document that you execute together that says this is something we both agree to. And the reason for that is one parent can never sever the parental rights of the other parent just by signing some documents. And so when you execute this parental appointment of guardian, you're basically saying, me and my spouse, we both want to assign this responsibility to these trusted persons. You ordinarily would pick one person, and then you would have a successor underneath that, and maybe even another successor underneath that as a backdrop, so that you're always sure that you're going to be able to get someone that you would want and trust to raise your children. Without it, the courts decide. And important to know is that no matter what you decide, no matter who you assign, the courts can always override it if they think it's in the best interests of the child to do so. So this isn't ironclad, but typically the courts will honor your wishes. They will typically look, and unless there's a really good reason to override them, they'll pretty much honor your wishes so long as you have that parental appointment of guardian. So just to recap, we went over 2 documents that help you plan for incapacity, your durable power of attorney, manages your finances, your healthcare proxy, manages your medical decisions. We talked about 2 documents that are meant to help you handle things after you're gone. So that's your will. That helps figure out how to distribute your assets after you're gone, among other things. And then your trust, which helps reduce your probate exposure, might be able to help reduce your tax exposure and enhances the privacy of your distributions after your death. And then we talked about that one document that's of particular importance for parents with minor children, and that's the guardian nomination, and that's applicable in both scenarios, incapacity and at death. And so those are what I believe are the 4+1 most important documents to have for your estate planning needs. They're certainly not the only documents. There's plenty of documents in here that we include in our estate plan packages that I didn't mention here, but they're also very important, and I'll probably talk about those in another video. If you have any questions, of course, always you can give me a call. or go to talk.tnllp.com and set up a consultation with me. I'd love to talk to you. I'm a Massachusetts attorney. I'm licensed in Massachusetts, so I can help Massachusetts clients with estate planning. But if you just wanted to have some basic questions or maybe see if I have a referral, you can call me about that. We also have attorneys licensed in California and Texas. And so if you're in either of those states, those attorneys would be able to help you with your estate planning goals. I'd love to hear from you. Give me a call anytime. And thank you so much for watching. If this was helpful, give it a like and leave a comment with your questions. We read them, and they often become future videos. Subscribe so you don't miss what's next. And head to book.tnllp.com to grab a free copy of Gene's best-selling book on securities and crowdfunding. It's a whole new business.